They confirmed that the darkest nightmares you might have had during the Bush presidency were at minimum plausible. People pulled off the streets without warrants on the order of the president. U.S. military strikes on American soil because of purported terrorism. Newspapers, radio, television, the internet restricted by a declaration of urgent necessity. None of it happened. In our third story in the countdown, we learned today that Mr. Bush's Justice Department thought all of it could have and could have legally. The current Justice Department releasing 9 Bush-era memoranda late this afternoon. Attorney General Eric Holder citing transparency and openness in a statement, though there are other still classified documents yet to be made public. But the memorandum, dated October 23, 2001, from the Assistant Attorney General John Yoo, is plenty. It is 37 pages, reading in part. We conclude that the President has both the constitutional and statutory authority to use armed forces in military operations against terrorists within the United States. Not clear enough? How about the memo dated March 13, 2002, concluding that the Commander-in-Chief's power to transfer prisoners captured in war is not restricted by the Torture Convention, and that al-Qaeda and Taliban prisoners are not entitled to POW status. And while that sounds like something we have heard before, a little gem on page 20 of the same 34-page document may give everyone pause. Quote, "In sum, historical practice firmly supports the power of the President to transfer and otherwise dispose of all, emphasis included, individuals captured incident to military operations, and not merely those individuals who may technically be classified as prisoners of war under relevant treaties." There were also memoranda suggesting that the government could put new restrictions on press and speech, and one contemplating ways to use wiretaps without warrants. 2 of the 9 memos came later and constituted an attempt at a cover, if not the cover-up, October 6, 2008, just before the presidential election. Quote, "Advised that caution should be exercised before relying in any respect on the memorandum authority to use military force to combat terrorist activities within the United States." And January 15th this year, days before the inauguration, quote, "Certain provisions stated in several opinions issued by the Office of Legal Counsel in 2001 to 2003 respecting the allocation of authority between the President and Congress in matters of war and national security do not reflect the current views of this office." Let's call in FindLaw.com columnist, author of Worse Than Watergate and Broken Government, former Nixon White House counsel John Dean. John, good evening.
John, good evening.
Keith.
Can we overstate how bad this was?
I don't really think so. You know, during the Civil War, they called Lincoln a constitutional dictator. Reading these memos, you've got to almost conclude we had an unconstitutional dictator. It's pretty deadly and pretty serious what's in these materials.
One could argue that in a time of widespread violent crisis, were we to have one in this country, that maybe the military could be used, maybe it would be needed to be used against terrorists. Maybe you could seize terrorists and worry about the legal niceties later. But isn't the flaw in this situation contained in this question? Who in this formula was supposed to decide that these were terrorists?
Well, according to these memos, it really is rather limited to the President of the United States, and there are no guidelines as to how he might define or describe who was or was not a terrorist. So that is the flaw. You put your finger exactly on it.
So that's the scenario that when we were all assured that any of these suspensions of habeas corpus would apply only to American citizens or non-American citizens, that was the catch in it. If you were pulled off the street and you said, wait a minute, I was born in this country, I've got to go see a judge, I've got to show you my birth certificate, you'd never get to see the judge. It wouldn't matter whether or not you were born in this country.
Exactly right. This is indeed the problem we've had with some litigation with some of the detainees. The president can unilaterally, or theoretically even somebody he delegates, can decide who indeed can be incarcerated and who cannot. That's why I say this is pretty close to being an unconstitutional dictator in any definition under the law of this country.
Do these memoranda, and again, we've only seen a couple of them and only for a couple of hours, do they at this point offer any insight into any of the other Bush policies like torture or waterboarding? Do they help us contextualize them?
I think, Keith, they're good examples of what you can call the corporatization of government law. And by that I mean, in corporations you tend to have lawyers who have set their goal as to where they want to take a given argument, and they've decided where they want to go before they start writing the opinion. That's what's happened in this instance. These aren't fair allocations or analysis of what indeed the law is. It's an effort to indeed push a position and back it up with legal reasoning.
And those last two memos, the October 2008 one that says advise that caution should be exercised before relying on any respect on one memorandum, and the one from January, the one that says the current positions are not reflected in the views of some previous memos. Does the old cover-up is worse than the crime thing apply here? Are those last two, pay no attention to the previous memos, more damning than the rest?
Well, indeed, this is pretty close. I don't give evil motives to anybody involved in this, but certainly there is some CYA in here as far as cover-up. And I think that certainly comes through in these last two memos you mentioned, where they're really repealing the earlier ones. Someone's protecting themselves because these opinions, while they sat on the books for a long time and for literally years of the Bush administration, it wasn't until really the final days of the administration they decided, well, we better clean this up and repeal these and say these aren't standing precedents.
What does it say about what we need to do now in terms of investigating all this, John, now that we have is this the scale tipper for everybody?
It could be because the public is going to be aware of a lot more than they were aware. There is an investigation that's been ongoing. It started in the late in the Bush administration by the Office of Professional Responsibility. And I think that investigation, which we've heard a little bit about, is going to be very hard to suppress now. As lawyers get in and look at the strength and weaknesses of these arguments, and they're primarily weaknesses because that's why they were indeed repealed, I think that the Office of Professional Responsibility may make some very strong recommendations that could include prosecution.
John Dean, the author of Broken Government and Worse Than Watergate, and who knew we would have to congratulate George Bush on his restraint. Great, thanks, John.